This is the second part to the first episode for 2025 of the real crimes of Kurri Kurri. There was a diverse range of offences, which I think is typical of many towns in New South Wales. Lots of different petty crimes happening in homes, on the road and down at the shops. First case is drug driving. The defendant was caught driving with THC in her system. THC comes from cannabis. The defendant argues the cannabis has been prescribed to her for medicinal purposes. First issue is the magistrate doesn't accept that the online prescription paperwork from an online doctor website is of the relevant standard. The defence solicitor explains that the defendant, who's 33 years old, lacked the knowledge and education and was under the belief that it was prescribed, which leads to the next issue. The court hears how the defendant took the advice of a highway cop about the cannabis when caught the first time. The magistrate questions why the defendant accepted the advice from a highway cop rather than a doctor for their medical problem. After taking the advice from the cop and not the doctor, the defendant then went on to get caught with THC a second time, which is why we're here at court. The person is sentenced to a community corrections order, fined and disqualified. In many of these disqualified cases, it's common to hear about the need for a licence. For example, they need to drive to work, school pickup, driving sick parents to medical appointments, or driving their partner to work, etc. I think the takeaway message for us outside the courthouse is to consider the need for a licence when deciding to do the traffic offence. Also, talk to your doctor about what medication you are taking and how it affects your driving, including if it will be detected in a roadside test and result in an appearance at the New South Wales Local Court. Next to be sentenced is the guy who attempted to choke his wife. The court hears how they have been married for more than 30 years. However, the relationship has been strained during the past couple of years. The magistrate labels this choking as dangerous behaviour and reminds everyone how many years he could be locked up for. In the end, the guy is placed on a number of different orders, including a supervised community corrections order and a good behaviour bond, plus there's an AVO in place to protect the wife. Next is another case that involves partners, a man and a woman. However, these two have ended their relationship but are still living together and co-parenting their kids. They are here because the police have applied for an AVO to protect the man from the woman. The man and the woman stand side by side at the defendant's microphone as the magistrate asks the woman how she wishes to respond to the application. Will she agree to the AVO without admissions or oppose the application, which will take it to a hearing? The man, who's the person named in the order that needs protection from the woman, tells the court he does not want the order to be made. Before the magistrate can act on this request, they need to check that the person in need of protection is not being pressured or intimidated into not wanting the order. The man is asked a couple of questions. In my opinion, he's the tallest guy in the courtroom and very much holding his own. He doesn't look like he's being intimidated as he slightly bends down to speak into the microphone. Together, this former couple appear comfortable standing and talking side by side. They sit together in the gallery and they leave together. They appear, as they say, two people still managing to conduct business while co-parenting without conflict. They just aren't in a relationship anymore. Whatever happened that started their AVO journey seems to be something they are handling themselves. The magistrate decides that if the woman can be of good behaviour for the next 6 months, then this AVO application will disappear. However, if she reappears back at court, the application will also reappear. The man and the woman agree and leave together. The next case felt a bit like two guys in their 60s having a frank conversation about being the bigger person when it comes to getting into an argument with a grandchild. Except one guy is a magistrate who could sentence the other guy to jail. And the other guy is in a position to be sentenced for an argument that sounds like he could have prevented from ending up at the New South Wales Local Court. Story goes, this happened in a backyard in Western in November 2024. We hear the defendant was frustrated with his grandson, lost his temper, and a minor assault followed. The magistrate and the defendant agree that they are both of the age where they know what should happen in a situation like this, that is, walk away. In the end, the guy is sentenced to 2 years good behaviour bond, plus an AVO is finalised to protect the grandson. The next case involves neighbours. Rather than go through who said what, I think we, the general public, should hear about this case because it's your behaviour that you need to be accountable for. The other person can be way more out of control, but it's you standing in front of the magistrate and it's going to be all about your behaviour. So we hear all about the ongoing neighbour conflict and also about the defendant's personal circumstances. So the situation gets to the point where the police become involved, and it's inferred the police successfully calm everyone down. In my opinion, the turning point in the case is where the magistrate points out that the defendant waited for the police to leave and returned back to the conflict. I think behaviour like that highlights poor decision making, and it's the poor decision making the court, in my opinion, is looking to deter the person from doing again. Last sentence is the mum who in November 2024 finally got to go out with the girls. The legal issue with this girls' night out occurred when this mum is driving the girls around Kurri at 3 a.m. with a blood alcohol level of 0.089. That's called mid-range drink driving. It's this mum's first time in court, and after some discussion, the magistrate makes the mum a one-time only offer. The mum, whose licence was suspended on the roadside, will have her licence suspended for a little longer and was given a conditional release order for 18 months on the condition that she doesn't reoffend. In the next part, I will discuss all the no-shows whose real crimes of Kurri were proven in their absence.